Hi, my name is Prakash. I am from Chanakya National University and presently I am an intern at LEXCLIQ. In this video, we will be talking about public prosecutors and their function in the judicial system. A crime is an offence which is done not only against the victims but also against the society, and hence the primary function of a public prosecutor or an assistant prosecutor is to be the counsel from the side of the state. Their job and their function also entails representing the counsel in criminal appeals and revisions. Public prosecutor and their definition is given in the Criminal Procedure Code under section 2, where it says that any person as defined under section 24 is a public prosecutor, or any other person who helps the public prosecutor into conducting the prosecution. That does not include the assistant public prosecutor, because the definition of a person of who is an assistant public prosecutor is given under section 25 of the Criminal Procedure Code. Public prosecutor heads the prosecution from the side of the state in the court of the Session Court and the High Court, whereas the assistant public prosecutor, they conduct the cases basically in the magistrate courts. In the magistrate courts, Metropolitan Magistrate Court, magistrate of courts of magistrate of first and the second class. The assistant public prosecutors are given under section 25. That can also include police officers when needed, but it has been very strongly contradicted and repulsed by the judiciary, asking that the legislative and the judiciary should be separated as said by the DPSPs in the Constitution of India. The eligibility of a person to be appointed as a public prosecutor in the high courts or the districts are given under section 24, subsection 7, where it says a person shall be eligible to be appointed in high court as public prosecutor if he has been in practice as advocate for not less than 7 years. However, it has been clarified by section 24(9) or subsection 9 of the Criminal Procedure Code that the period during which a person has been in practice as a pleader or has been rendered service as any prosecuting officer by whatever name called shall be deemed to be the period during which such person has been in practice as an advocate. Hence, the term needed for the eligibility of public prosecutor has to be all in all in total not less than 7 years. The appointing authority is the state government in the present case, but the condition is that the state government should be working under the consultation of the High Court. This has been given in section 24, subsection 1 of the Criminal Procedure Code. The central government or the state government may appoint, for the purpose of any case or class of cases, an advocate who has been in practice for not less than 10 years as a special public prosecutor. This has been given in section 24, subsection 8 of the Criminal Procedure Code. The classification regarding the period given in the subparagraph A is above applicable here also, as in the eligibility for a person to be a special public prosecutor, i.e. should be an advocate who has been practicing as an advocate for at least 7 years, and that is the eligibility for special public prosecutor also. The appointment of a public prosecutor under section 24(1) of the CRPC in the High Court is different from the appointment of a public prosecutor for the district courts, and therefore the notification appointing public prosecutor in district court did not enable the public prosecutor to represent state in the appeal. This has been given in K versus State of Karnataka case, as in for appointment of public prosecutor in district courts is different, as in district court it has been said it shall be done in consultation with the sessions court, which is different as the consultation of High Court is taken when it comes to the public prosecution head in the High Court. In this case, it's the district court, and the district court, the district judge, he prepares a panel of names who in his opinion is fit to be a public prosecutor or additional public prosecutor. This has been given in section 24(4) of the CRPC. If there is any other person who has been working in the directorate of the public prosecutors, if under the head of public prosecutor, even that person is eligible to be a public prosecutor, and the district court and the district judge can appoint anybody from that panel and from that directorate, and if in other case he can also appoint from the panel that is being given by the district judge. Hence, that is how also the eligibility of the prosecutors, public prosecutors in district courts is the same as the eligibility for the public prosecutor in the high courts, and that is how these councils for the state are elected, and that's how they function in our judicial system. Thank you.